Good morning to everybody. I would like to start out with a general overview of sentencing in Germany. We'll then turn to sentencing in tax crime cases before answering the question if confessions have a significant effect in tax crime cases in Germany. Then I will turn to plea bargaining with specific reference to tax crime cases, and by doing so, we'll discuss the combination of what is called factual plea agreements in tax law, not in tax crime law, but in tax law, and plea bargaining in tax crime cases. So let me start out with some remarks or some general overview remarks of sentencing in Germany. German sentencing is fundamentally based on broad sentencing ranges for individual offenses. The so-called basic formula of Section 46 of the German Criminal Code provides indications that serve to find the appropriate penalty and thus counteract the broadness of the sentencing range. The process of sentencing presupposes a broad judicial freedom in order to consider the individual case, especially regarding the diversity of different factual circumstances. This goes hand in hand with a broad range of reaction instruments or reaction measures, which, in contrast to concrete punishments, predetermined sentences, or sentencing guidelines, enables the individual case to be adequately assessed. In order to approach the individual case, Section 46 of the German Criminal Code is based on the general term of guilt, which is supplemented by some criteria of sentencing in a non-exhaustive manner and without further weighting by the legislator. These aspects include, for example, the offender's motives and objectives, his or her prior history, and the consequences caused by the offense. Section 46 also mentions the offender's post-offense behavior as one of these aspects of assessment. In this respect, it is recognized that a confession by the offender is to be taken into account as an essential aspect of the offender's post-offense conduct in sentencing and has a mitigating effect on the sentence. The extent of the mitigating effect depends on the circumstances of the individual case, such as the given evidence. However, due to the vagueness of the individual sentencing aspects, as well as the lack of legal guidance of the sentencing process, German sentencing has also been facing criticism for some time. Proposals for reform that call for a comparative approach to sentencing to specify the sentencing process inevitably collide with the federal court's actual maxim of judging the specific case. After all, a comparative approach would likely have the tendency to abandon the assessment of all circumstances of the individual case and turn to a general comparative view. Other academic voices calling for actual sentencing guidelines, just like the ones based on the sentencing guidelines of 1980s US law, would at least reduce the ability to take into account the specific parameters of the individual case in favor of a rather mathematization of sentencing, and would therefore be incompatible with the current German sentencing law. Let me now turn to the practice of sentencing in criminal tax cases. When jurisdiction for appeals in criminal tax cases was transferred from the 5th to the 1st Criminal Law Senate of the German Federal Court in 2008, the latter, the 1st Senate, set new practice-relevant standards. Since then, however, the Senate has somewhat neglected its own general maxim regarding the assessment of punishment. Thus, the Senate has emphasized that the details of the offense were not sufficient to impose the penalty schematically only on the amount of tax evasion. As pointed out above, This requirement is consistent with the legally required penalty assessment. At the same time, however, the Senate stated that at any rate in the case of a 6-digit tax evasion, that is from 100,000 euros on, as you know, the imposition of a fine, in contrast to a prison sentence, could only be appropriate if there were substantial mitigating facts. In this way, the federal court paved the ground for a penalty assessment practice based on the amount of the tax evasion or the tax fraud. In addition, the ratio of the tax evaded to the tax paid in relation to the period of the offense, as well as in relation to the lifetime, a confession and a possible payment of the evaded amount were somewhat to be taken into account. However, the payment of the evaded amount hardly had a mitigating effect if it is owed anyway, which is usually the case, and if it can be paid by the accused without any recognizable effect or loss of lifestyle. Nonetheless, the amount of the evasion was thus placed at the center of the sentencing process instead of the procedure according to Section 46 of the German Criminal Code. Ever since that landmark decision from 2008, the amount of the tax evasion stands as the central criterion. To no one's surprise, on the basis of this decision, guidelines on the assessment of penalties in criminal tax cases were developed by the criminal law courts. It is argued that this practice serves legal certainty as well as equal treatment, which also gives the tax authorities, public prosecutors, and criminal law courts sufficient freedom. Moreover, the federal court ruled that in the case of evasion, amounts in the millions, that is from 1 million on, a suspended prison sentence could only be considered if there were particularly substantial mitigating reasons. Only then probation or suspension sentences should be applicable. This led to the conclusion that a suspended sentence could only be imposed in cases where the damage to tax assets was between 50,000 euros and 1 million euro. If, however, a suspended prison sentence is imposed in an evasion case involving millions of euros, this now requires special justification and therefore special mitigating grounds. In addition, the federal court ruled that in case of an evasion amount greater than or equal to 1 million euro, the so-called penalty order procedure, or Strafbefehlsverfahren in German, should not be applied. The penalty order procedure under German law allows for a conviction without having an oral court hearing. In the federal court's view, the public has a right to get informed of cases of large-scale tax damages. This landmark decision was expressly approved by the legislator, which in turn led courts to regard this practice as an established standard for assessing punishments. Without the legislator putting this into legal form, the judicial ruling was still considered as established law. A de facto sentencing guideline was therefore established, only applicable in tax crime cases, not in other business crime cases. In the light of this, the fact that tax authorities have subsequently established penalty scales largely based only on the amount of tax evasion, sometimes varying in great detail with regard to the amount, is hardly surprising. In practice, penalties in criminal tax cases are widely imposed schematically and according to the rate of the amount of evasion. The mere amount of the evasion thus takes on the decisive role in sentencing of criminal tax cases and largely displaces the sentencing procedure according to the parameters of Section 46 of the German Criminal Code. Now, if we focus on what impact confessions have on the actual sentence in tax crime cases, two case groups can be identified. In the first group, an early confession no longer has a strong mitigating effect on punishment. In the second case group, a confession is not taken into account with regard to the guidelines for assessing tax evasions in the millions. Thus, while the confession loses decisive effects in the context of sentencing in average tax crime cases, it can have a significant influence on the expected sentence in other specific constellations of tax crime cases, above all related to the Crown Witness Rule, Kronzeugenregelung. If the defendant acts in due time as a key witness, under German law he would still remain a defendant, but we still call him a key witness or a Crown witness. In the terms of Section 46b of the German Criminal Code, his sentence may be significantly reduced or even waived. The Crown witness needs to voluntarily make his statement before the main proceedings have been started. The main proceedings in his own procedure, that is. With his statement, the defendant needs to either make a significant contribution to uncover a related offense or to prevent such an offense. Furthermore, a certain connection between the alleged and the disclosed offense is required for the benefit of this so-called Crown Witness Rule. It is sufficient that both offenses are part of an overall criminal conduct. In application of the Crown Witness Rule, the Bonn District Court, in a very prominent case last year relating to the Cum-Ex tax scandal, has thus imposed a suspended sentence for tax evasion amounting to 447 million euros for two Crown witnesses. Moreover, a confession of a key witness is also considered by the courts in the context of Section 56 of the German Criminal Code, and thus in the light of whether the execution of the sentence can be suspended if probation will be granted. In this respect, it is regarded to be a special circumstance which, due to the voluntary cooperation and the confessed admission, provides a clear counterweight to the offenses and thus leads to the expectation that the person will refrain from further criminal acts. Consequently, the confession of a Crown witness has a significant effect in two respects. This double mitigating effect is supported in case law by the fact that a mitigation of the sentence for the Crown witness still has to be considered even if one of the other defendants has previously made use of an instrument that we call self-disclosure in tax crime cases. A self-disclosure, or strafbefreiende Selbstanzeige in German, a self-disclosure in a technical sense represents the second way in which a confession becomes highly effective in criminal tax proceedings. This legal institution is specifically regulated for tax evasion and restricted to cases of tax evasion in Section 371 of the German Fiscal Code. It constitutes a personal ground for the complete exemption of a sentence. In addition to the fiscal purpose of uncovering hidden tax sources, this instrument is also based on the idea of offering the tax offender an incentive to return to tax honesty, particularly in view of the effort to uncover hidden tax sources. However, a self-disclosure will only exempt the taxpayer from a penalty if and as long as the self-disclosure supports the discovery of the relevant tax source. Therefore, if the fiscal authorities have already discovered the tax source, self-disclosure in this legal sense is no longer possible or applicable. The exempting self-disclosure requires complete and correct information on all tax evasions not subject to the statute of limitations and related to the respective type of tax. The self-disclosing person must express that the previous information, his own previous information, was incorrect or incomplete, and that he wishes to now submit correct and complete information. The self-disclosure, therefore, comes, at least in a practical sense, comes close to a confession. Thus, the impression that a confession by a defendant in criminal tax proceedings has a special status is becoming more firmly established. The exemption of punishment under Section 371 of the German Fiscal Code is explicitly limited to tax crime proceedings and offers a unique way, not open to other cases of business crime law. Moreover, the Crown Witness Rule in particular is able to soften the sharp sentencing guidelines in two ways, thus providing a further incentive for early confession. Let me now turn to plea bargaining in tax crime proceedings. As is well known, the German trial with a public, oral, and direct hearing of evidence compared to the preliminary proceedings serves to determine the true facts of the case as the basis for the court's decision. The trial's objective is to find the so-called material truth or substantive truth in the sense of the closest possible approximation to historical reality. We've heard this from Gerhard Dannecker today already. The historical events have to be reconstructed in the best possible way. A regulation that leads to the negotiation of truth in German criminal proceedings is the plea agreement procedure of Section 257c of the German Criminal Procedural Code. This section codifies the practice of plea bargaining and thus provides a legal basis for consensual agreements in criminal cases. Although the regulation itself is being discussed controversially, it is frequently applied in legal practice. Yet the plea bargaining procedure rather indirectly affects the assessment of truth. This is because Section 257c restricts agreement on the legal outcome as well as procedural measures at the trial level and the conduct of all parties to the proceedings. The factual basis, as well as the verdict of guilt itself, however, cannot be subject of a plea bargain. According to the legal concept, the sentence, but not the conviction, is allowed to be the subject of a plea agreement. Accordingly, the factual basis, for example, the quantity of the amount in fraud cases, still have to be determined by the trial court. Thus, the facts of the crime, meaning the way certain crimes have been committed, and guilt are not negotiable. Nevertheless, a confession as part of the plea agreement is in the center of the plea bargaining process. A confession often makes further hearing of evidence unnecessary and therefore shortens the trial, which is crucial, taking into account that German trials often end up with more than 100 days in court. As you might have heard, just to give you an example, the Munich diesel case, for example, dealing with the diesel scandal, which has started in September 2020, as the court just told us, will not end before mid-2023. So this is just to give you an example of how long German trials can actually last. Although a plea bargain could legally be executed without a confession, in practice, the vast majority of plea agreements are based on a confession. In these cases, the confession usually represents the basis for the conviction. Since a confession remains at the center of a plea agreement and the content of a plea bargain may be negotiated, the content of the confession is often also negotiated. This means that, at least in practice, the conviction is also, at least indirectly, negotiated. In order to validate the confession, the court, which is still obliged to investigate the material truth, must rely on the contents of the files. This means that the quasi-waiver of the hearing of evidence in court as a result of the plea agreement only produces a true result if the contents of the file present or represent the truth. Thus, the confession has a mitigating but not a truth-securing effect. Let me now turn to factual plea agreements in German tax law. Even if one assumes the legal ideal case of an agreement in criminal proceedings, there is nevertheless a way in criminal tax proceedings to reach agreements on the factual basis as well. The fiscal legal institution of factual plea agreement, or in German tatsächliche Verständigung, is not regulated by law, but has been applied in practice for a long time and can be considered to be well established in German fiscal law. It is applicable in tax cases where the actual relevant facts are uncertain. This institution of a factual plea agreement leads to a binding agreement between the tax authority and the taxpayer on the facts relevant for taxation in a specific case. This two-sided consensual procedure is established with regard to the relevant factual circumstances. Accordingly, the factual plea agreement is directed as well as limited to the determination of the facts. Its general purpose is to eliminate uncertainties and inaccuracies concerning the relevant actual conditions. The factual plea agreement is an instrument which enables the parties concerned to negotiate facts and the actual situation of the case, and thus to determine the ultimate basis for the outcome of the tax case. Although there is a prohibition of creating an improper link between criminal and tax proceedings, things turn out differently in the real world. However, there is no prohibition, as there is no prohibition on combining a factual plea agreement with a criminal procedural plea bargain, the combination of both instruments leads to a comprehensive negotiation of facts and legal consequences of a tax offense, and often of the tax case itself. In the light of this, both facts and sentences can be the subject of a combined consensus and plea agreement. As a result, criminal tax law is far more applicable to consensus between the parties than is actually inherent in German criminal law. From an overall perspective, criminal tax proceedings in Germany prove to be special in two aspects. First, with regard to sentencing, criminal tax cases are based on sentencing guidelines that are generally rejected by German criminal law. As a result, sentencing procedure according to Section 46 of the German Criminal Code is marginalized. In this way, sentencing in criminal tax proceedings cuts its own path. This unique path is not prescribed by law and not only gives preferences to guidelines over a case-by-case approach. Moreover, it also somewhat disregards the sentencing aspects that are actually to be taken into account by law, such as a confession. In any case, fiscal considerations dominate the effect of a confession. An early confession has a significant mitigating effect if it is combined and I'm summarizing, as you can see, with the Crown Witness rule, or if a confession is part of a self-disclosure with a penalty-exempting effect. Second, criminal text proceedings in Germany are unique with regard to the practice of plea bargaining. While plea bargaining in criminal proceedings in general only allows the parties to agree on the legal outcome of the case, plea bargaining in text proceedings offers the unique or sole opportunity to negotiate about the facts of the case as well. The combination of factual plea bargaining with a plea agreement in text crime proceedings leads to an agreement on the facts of the case as well as on the legal consequences of the offense. I leave it open, and I leave it open to discussion if such a combination helps establishing the truth, but it helps reaching a consensus. Thank you.